I said, what? That's so dry.
No, I was asking about the recordings. Where can we find the recordings for sessions? Like if you were to miss a class.
They're on YouTube. I thought he sent them. He didn't send it. You don't see it?
He doesn't send them, so we just log on to you. We just go into YouTube.
Hold on. Let me ask him for the instructions so he could jump on. Let me ask him right now. Okay, so I sent him a message. So remind me a little later in case he doesn't come right on. Because I know they have other classes he have to start, but I send the message. Okay, he's online now. Let's see if he starts typing. He's typing. Mm-hmm. He's typing. Is he coming in? His mic is still off.
Good afternoon.
Good afternoon. We're trying to reach Miguel for 1 minute. Just hold on 1 second.
Okay.
Oh, you say we'll do right now. Your computer at the office. I can't talk to you. Okay. Okay, let me hear what he's saying. I asked him to type it out. Say go to YouTube and type in BIFS EDU. It's in cap, BIFS, and then EDU. And he said he'll upload them tonight. Got that?
Yes, ma'am. Thank you.
Okay, all right. If you don't, then send a message so I could be on his tail. All right, so everybody had a wonderful weekend. Yes? You had a whole holiday?
Yes, it was good.
Yeah, I wish there was another one coming around the corner. Okay, so Cleopatra, we missed you last week. And she went silent.
I apologize.
That's all right. Don't worry. Your case is right here waiting on you.
Okay, which one? I was trying to determine which one it was.
You had to do? You were doing Finco and Teresita Johnson.
Okay. I read them.
Okay. While we wait on you to get your thoughts together, we're going to do Sylvan and then we'll do Cornell versus Maltby. So Sylvan was Dorame.
Yes, ma'am.
Okay.
So Sylvan was a case between, well, Sylvan was the applicants in this court order against Royal Bank of Scotland. Sylvan, let me just give you a little briefing about the case. This is an appeal brought with the permission of Chadwick L.J. against part of the judgment of a pardon J given on the 11th of October 2002. By his judgment, Patton J dismissed all claims, and he was the judge, of Sylvan Properties Limited, in quotes, Sylvan and Chart Enterprises Incorporated. The claimant is, who is the claimant in this action? Against the first defendant, Royal Bank of Scotland, and the third defendants, Nigel Watt and Timothy Harris. So, in a nutshell, Sylvan had these properties that they mortgaged to Royal Bank. They were unable to pay a loan for these properties. So Royal Bank then got what they call a receiver, or pretty much the same as a let's see, I guess like a caretaker.
Yeah. The
Um,
receiver is, yeah, go ahead.
care for these properties. Now, in this case, a caretaker is to work on behalf of the mortgagor and not the mortgagee. And Sylvan, who is the mortgagee, thought that the caretaker should have their best interest at heart. And so that wasn't the case, because they wanted the caretaker to sell the properties at the best value for these properties, so that, I guess, in the event when they pay off these debt, they'd have some residual left over. When the receivers didn't have that in mind, they were just trying to get these properties sold so that they could pay off the debt that was existing. So they went to the Court of Appeal to try to challenge the judge's ruling against what the receivers had done. And by law, that was not their responsibility, pretty much.
Mhm.
Their whole responsibility was to have the best interest of the mortgagor, whom was the bank at the time, and that was what they did. And so I think there was a part in here where the judge spoke about, let me find it, sorry.
Fiduciary duty of care.
Yes,
Mhm.
yes, that's the word. He was like, they did what they needed to do on behalf who they needed to do it for. And so all of their, well, not all, but Sylvan's case was dismissed
Mhm.
on them not paying the loan and having to have a receiver put in place to actually sell.
So, because he said it is within the discretion of the receivers to sell the property without attempting to increase its value.
Yes, yes.
So the receivers were entitled to halt applications for planning permission, and there could be no imposition on the receivers of the obligation to take certain pre-marketing steps, as was contended by the claimants.
Right. Mm-hmm.
That is another thing that you all have to remember in mortgage property, especially a mortgage property that is a going concern. Once you appoint a receiver, this case of Sylvan Properties versus Royal Bank of Scotland comes into play. Because as you can see, he has a fiduciary duty. So even though he will be acting on behalf of the mortgagee, he still has to make sure that he sells the property, and he has to sell it as is at that point in time. He doesn't have to take anything else into consideration. Okay. Now, who's doing Cornell? I think that's Demetria.
Hi, Demetria isn't ready.
She is not ready.
No, mom.
So come back to you later.
Yeah.
Okay. Y'all heard that, right? She said, come back to her later. Okay, let me see what we're gonna do. Cleopatra, you ready?
Which one you said, Evelyn
Finco.
Fritz?
Finco and Teresita Johnson.
No, I don't see that. I have. Okay, which one is it?
That wouldn't be from this, the ones just sent, that would have been from before.
I don't see Teresita. I remember reading it, but I don't see my printout.
You don't see your printout? Google it. Finco and Teresita Johnson, Terresitta. And put plus Supreme Court. It'll come up.
Okay.
In the meantime, Janine, you want to do your peace holdings?
Okay. Oh,
Janine, you want to do yours?
Hello?
Yes, do you want to do yours?
Oh, I can. Try.
Okay, all right. Peace holding and First Caribbean.
Okay. In this case, Peace Holdings was the appellant and First Caribbean was the respondent. Peace Holdings in 2006, First Caribbean loaned Peace Holdings over $30 million to develop a land in Ocean Place, a condominium on Paradise Island. The loan comprised of 6 advances. The appellant defaulted on the loan and the development remained unfinished and the loan unpaid. The loan was called in 2012, giving 30 days for repayment and agreed to extend the facility for a further 6 months if $3 million was injected by the appellant. That did not happen, and the receivers were appointed to initiate sales proceedings. Peace Holdings alleged that the debenture was invalid and unenforceable and sued to stop the sale of the property. Preliminary point dismissed and cost reserved to conclusion of the appeal. There was a notice of appeal in March 2014. The appellant challenged the judge's decision. There was a notice of motion applying to strike out that decision on the ground that it was an interlocutory judgment requiring leave of the court or the court below or the Court of Appeal. Or the Court of Appeal pursuant to Section 11F of the Court of Appeal Act, which was not obtained. There was also a notice of intention filed in May 2014 by the respondent to rely on the preliminary objection that grounds 2, 3, 4, and 10 of the notice of appeal were relative to interlocutory decisions which could not be appealed without leave of Supreme Court or the Court of Appeal. At the end of the hearing, they reserved their decision. Peace Holding commenced proceedings in the Supreme Court in 2012, claiming breach of contract for not honoring a performance bond, agreements for funding for completion of the project, and operating and marketing costs of Ocean Place condominium. They further claim that the debenture, inclusive of the supplemental and collateral memorandum of deposit deeds, was invalid and unenforceable for non-compliance with Section 156 of the Companies Act on the basis that the shareholders had not approved the debenture. The action did not expressly challenge the exercise of the respondent's contractual or statutory right to sell the property. The respondent filed a defense and counterclaim in 2013, defending the appellant's claim, and they counterclaimed against Mr. Ballard, who signed as a guarantor for the loan, for repayment of the loan secured by the debenture. He denied responsibility for repaying and counterclaimed that him and the appellants were under extreme pressure and acted under economic duress and under the undue influence of the respondent. The respondent then filed for a summons applying for an order for the sale of the property. Sorry, I'm reading off this laptop and it freezes.
Oh, Lord. And I tell you, you gotta print these things out.
Yeah, I have time to do that.
That always happens.
Okay, let me see if I can on this.
Okay, this one have some key pieces of the legislation in it. So while your thing freezing and unfreezing, God, they say at paragraph 14, they said the fact should not be lost sight of that the relationship between the appellant and the respondent was one primarily of a mortgagor, that's the appellant on the one hand, and a mortgagee, the bank on the other. The action was quintessentially one of a mortgage. It was in this context that the underlying issues between them were joined on the application before the judge. So section 21 through to section 26 of the Act, as the law of conveyancing, provides for the powers that are incident to the estate or interest of a mortgagee. Section 21A, so far as material in the context of sale by a mortgagee of mortgage property, provides as follows, quote, section 21, subsection 1, a mortgagee, where the mortgage is by deed, shall, by virtue of this act, have the following powers to the like extent as if they had been in terms conferred by the mortgage deed, but not further, namely a power where the mortgage money has become due to sell or to concur with any other person in selling the mortgage property or any part thereof, either together or in lots, by public auction or private contract, without being answerable for any loss occasioned thereby. This power of sale granted to the mortgagee is applicable only if, and so far as, a contrary intention is not expressed in the mortgage deed and shall have effect subject to the terms of the mortgage deed and to the provisions contained in it, subsection 3 of section 21. So that's the first thing you have to remember. When the bank is exercising its power of sale, you have to check and see whether or not there is a contrary intention expressed in the mortgage deed that is different from section 21, subsection 1A. And there have been instances before the court where that section was contrary. And the bank didn't realize that. So it says in paragraph 19, in the third place, it is not the case of the appellant that the power of sale that inheres in the bank as a mortgagee, whether by deed between it and the bank or by section 21 of the act, was not operational on its default of repayment of the loans to the bank. And he said this was not advanced either before the learned judge or before the court. Then you move to section 22. And that contains the provisions regulating the exercise of the power of sale by a mortgagee. And he says, in the context of the issues framed earlier by this court, in relation to the grant of the respondent's application by the learned judge, under section 27, subsection 2, section 23 stipulates the effect of a mortgagee exercising the power of sale conferred by the act and inferentially by the mortgage deed. And then he quotes section 23, subsection 1 and subsection 2. He says a mortgagee exercising the power of sale conferred by this act shall have a power by deed to convey the property sold for such estate and interest therein as is the subject of the mortgage, freed from all estates, interests, and rights to which the mortgagee has priority, but subject to all estates, interests, and rights which have priority to the mortgage. So all that means is that if there is a prior claim on that estate, that goes first, and then what is left belongs to the bank. Where a conveyance is made in professed exercise of the power of sale conferred by this act, the title of the purchaser shall not be impeachable on the ground that no case has arisen to authorize the sale, or that due notice was not given, or that the power was otherwise improperly or irregularly exercised. But any person damnified by an unauthorized or improper or irregular exercise of the power shall have his remedy in damages against the person exercising the power. So he says, if a mortgager could show that the power of sale was exercised on any ground outside these grounds, and those grounds were no case has arisen to authorize the sale, or due notice was not given, or the power of sale was otherwise improperly or irregularly exercised. So those are the three grounds that peace holding had to advance, which they didn't do. In order to bring a successful challenge. And then he went on to speak about the power of sale under section 27. He said in any action, whether for foreclosure or for redemption or for sale, or for the raising and payment in any manner of mortgage money, the court, on the request of the mortgagee or of any person interested either in the mortgage money or in the right of redemption, and notwithstanding the dissent of any other person, and notwithstanding that the mortgagee or any person so interested does not appear in the action, and without allowing any time for redemption or for payment of any mortgage money, may, if it thinks fit, direct a sale of the mortgage property on such terms as it thinks fit, including, if it thinks fit, the deposit in court of a reasonable sum fixed by the court to meet the expenses of sale and to secure the performance of the terms. So unlike the power of sale under Section 23, which is exercisable only by the mortgagee without the necessity of the intermediation of the court, the power of sale under Section 27, subsection 2, may be ordered on the application of anyone interested. So go on now. I just wanted them to make sure they get the law behind the power of sale. So what else did the court say? Janine? Janine? Janine, your computer still frozen? Or Janine is gone completely now? Or she's coming in? No, yeah, she's in. Janine? Janine, can you hear us or your thing's still freezing? Your computer? So what you have to realize is that when you're exercising the power of sale, that's the bank, and you're appointing a receiver, you have to be careful of the accompanying documents that go with that mortgage. And in this case, it was the debenture. Because under clause 11 of the debenture, the statutory power of sale of the mortgagee under Section 23 was invoked by the clause in the debenture. And in that clause, it said at any time after the bank has demanded payment of any money or the discharge of any obligation or liability secured by the debenture, or if requested by the company, the bank may exercise without further notice, without the restrictions contained in the Conveyancing and Law of Property Act, Section 22, and whether or not it has appointed a receiver, all the powers conferred on mortgagees by that act, as varied and extended by this debenture. and all the powers and discretions conferred by this debenture, either expressly or by reference to a receiver appointed under this debenture. So when a mortgagee conveys to a purchaser pursuant to the statutory power of sale, protection is given to the purchaser under section 21, subsection 1 of the Act. And any claim against the mortgagee arising out of such sale is converted under section 23, subsection 2 to damages recoverable by the mortgagor from the mortgagee or the person exercising the power of sale, not the purchaser. And then it gives you the quote from section 23, subsection 2. So this is a good case for you to read. Because talking about the mortgagee's power of sale.
Ms. Archer, I have a question. if you don't
Go
mind.
ahead.
Okay, when you're talking about power of sale, no, part of power of sale is vacant possession,
Mhm.
right? And you notify clients that you give them certain time to move to this and the next. Once they turn over the key, so for instance, some persons might decide and don't want to go through the headache of this long court proceeding and so forth. Once they turn over the keys, you can, legal action can stop, or you have to officially get everything done through the courts. You have to go to the courts no matter what, even though they willingly walked away.
But before you even go to the courts, you have to apply the Homeowners Protection Act. You have to do that first.
Okay,
And we're gonna go through that tonight. The Homeowners Protection Act. Because even though they walk away, they can still come back, you know.
even though they hand you the key? And say
They hand you
go?
the key, but there is in court and in law, there is a process.
Okay.
So that's why the first step you have to look at is you have to read the mortgage deed. And then you have to go to the relevant section in the Law of Conveyancing Act. Because even though you see when you read a lot of the cases that the mortgagee has a lot of rights, the homeowners protection more or less like stalls those rights. Because there's some steps that you have to go through. So it just gives them more opportunity to see if they could try and bring their mortgage up to date. They have more time to work with the customer. But this is a very good case on this condominium, and then looking at the relevant sections and being mindful that you always have to look at the accompanying documents that the mortgagee and the mortgagor signed. Janine, you had anything else you wanted to point out? You think she could hear us?
Miss Archer, she having a mic issue.
Or
She could-
okay.
You could
She
hear,
could
but we
hear.
can't.
Oh, okay, all right. Who should be next? Cleopatra, you ready?
Yes, ma'am.
Okay, let's go.
Okay, so we're looking at the Finance Corporation of the Bahamas Limited as the plaintiff and Teresita Johnson as the defendant. And this was between March 2019 and November 2019. It says striking out order 18, rule 19, duty of the mortgage on the sale of property. Basically, what it's saying that she they had taken the property from her for sale. She is disagreeing due to an appraisal that she had gotten on the property at 105, and they sold it for 70,000. And she is saying that, okay, she did not default, even though it would say that she was in breach of the terms of the mortgage. She failed to repay the loan to the plaintiff, and it fell into arrears. And that was because she was unemployed. So she would have defaulted on the mortgage. So they would have had the right to sell. So that was her basis of argument, which when they looked at it, they are saying that her defense is very sketchy. Like there's not enough information that she's giving for the reason as to say why they should not have sold it. And so when they went to court, she ended up having to actually pay. She ended up having to actually pay the cost of everything. You want me to go in more detail?
Read,
Section 11,
18,
18.
19, 18 to 19.
Okay, so 18 is saying this defendant having admitted in court that she ceased making the payments sometime in 2011 can hardly be heard to say now that she has a defense to the action itself, because she is trying to say she didn't default, but she did, because she wasn't working. She didn't make payments.
Mhm.
The plaintiff is a mortgagee seeking to exercise its power of sale under a mortgage deed, and the principles relating thereto are clearly set out by Frazier, Evans versus Commonwealth Bank and others in 2016. Okay, so should I go down into 29.1?
Yeah, so in that case, it cites the First Caribbean International Bank and Dr. Hiram Mitchell and
Yeah.
Carla Lockhart,
Yes,
right?
okay,
And then in that case, they relied on the English case, the common law case of Kirkmere Brick and Mutual Finance, which is
yes,
the case normally referred to for remedies
okay.
for real property. So tell them what it says.
Okay, the mortgagee must make an informed judgment, and because judgment is required, there are no steps which the mortgagee must definitely take. Number 2, generally it is for the mortgagee to decide on the manner of sale, if appropriate, after having sought expert advice. The property should be properly advertised sufficiently, frequently, and sufficiently widespread to reach the appropriate pool of prospective purchasers. And the mortgagee, that's number 3, is entitled to decide the length of time the property should remain available for sale. And subject to this, the property must fairly and properly be exposed to prospective purchasers. And number 4, the mortgagee is not under a duty to improve the property for sale and not under a duty to pursue or obtain a planning permission. And then they're saying the mortgagee is under a duty in a case such as this one to remove encumbrances like the grant from the property. But a mortgagee is under a duty to bring to the attention of prospective purchasers potential advantages that might be achievable, so that, for example, prospective purchasers ought to be informed of the property's development potential. And number 5, where the sale price is just above the sum required to discharge the mortgage's outstanding debt, the court will scrutinize the sale with particular care. And number 6, there's recognition that the fact of repossession can taint the property, so resulting in it only being capable of sale at a reduced price. Okay. And number 7, the mortgagee will not have breached his duty unless he is plainly on the wrong side of the line. Number 8, the mere fact that a higher price might have been obtained does not inevitably mean that the duty has been breached. And number 9, the burden of proving a breach of duty by the mortgagee rests on the mortgager,
Mm-hmm.
which she did not supply. So,
Yes. Mm-hmm.
so that is basically why she lost that. She didn't have any real defense. And if we look down at 22, it is saying that in an order that the defendant's defense and counterclaim filed in 2015 is struck out pursuant to Order 18 Rule 19 on the grounds that it discloses no reasonable defense, it is frivolous and vexatious, and it is an abuse of the process of the court. Okay, and like I said, so she is ordered to pay she's ordered to pay the sum that's left and damages of any, and if the cause of the action by that of the plaintiff to be taxed if not agreed, which basically still lose.
Mm-hmm. So you see, you can still bring a matter before the court, but you will lose if you don't have the grounds for it.
Right, because she didn't have enough information, and well, she is saying that she did not breach the contract, but she actually did, because she did stop paying. She was unable to pay because she was unemployed. So she did breach it, and they were in their right to sell it.
Mm-hmm. And I want you to see when you read these cases, especially when you just finish reading the sections from Crookmere Breck versus Mutual Finance, when it comes to the power of sale, you see the rights of the mortgagee.
Right.
He's not under duty to improve the property. So if you,
Right.
before, remember couple of years back, like 8 years back, when they were repossessing homes and people went in, before they left the homes, they actually broke the homes up. Some people took
Right.
out like cabinets, people took up the tiles. Well, they did it to their own detriment.
Right, because now it's less than what it was appraised
Exactly.
at, and it's damaged more. So you're not
Mhm.
gonna get half of what you may have gotten if it was at least decent.
Exactly. And then you still owe the bank.
Yes, when it's all said and done.
Mm-hmm. Mm-hmm. And so you would see there's a lot of things on the side of the bank as the mortgagee.
And she was successful in bringing it to court, but I mean, she still lost the case.
Yeah, she was successful in bringing it to court because she was the mortgagor. And so she has a right to be heard. But
Yeah.
she didn't have all of her ducks lined up in a row.
She would, like she said, if she was in default, which she is saying she was not, but she was in default.
Mm-hmm.
Because she was unable to pay, so it fell into arrears. And so they were within their right to take it and sell it at the market value
Right.
that they got.
And that's what a lot of the mortgagors don't realize. When you read the law of Property and Conveyancing Act and you read the section, it tells you after 3 consecutive payments. So after you've missed 3 consecutive payments, then the bank can exercise its power of sale.
You
It
said,
can go,
oh,
yeah, and decide whether they're gonna extend it, give you more time, work with you. And when it's ready, it could just put it up for sale.
okay. But isn't it also, even though you may say, okay, yes, they have repossessed it. Whenever they are doing something like that, you should still appear in court to see and look at the documents to make sure that everything is as it is.
Yes, yes. It's always good to defend yourself. With an attorney now, not like that other man
Right.
from the last class. Who wife abandoned him.
Mr. Mitchell.
Mitchell,
Not him. Don't do what he
Yes.
did. Bad example, bad example. Not a good one. So, yep. So who we have next? Bentek? And for its Caribbean? That is the Monaco. I thought I saw her on. How come she's disappeared? All right. Let's go, Mackenzie. And then we'll go back to doing Cornell.
Okay,
Jump-
good
jump in.
evening.
Good
Okay,
evening.
hello. This case was, hold on, let me help this out. Okay, so this case was between the plaintiff, George Damianos of DBA Damianos Sotheby's International Realty, and there were actually 4 defendants in this case. The first defendant being BOB. The second defendant was Windermere Island North Development Limited. The third defendant was Joseph Rich. And the fourth defendant was a Windermere Lender. I think LLC, does that stand for Limited Liability Company?
Yes.
Okay, yeah. I can call them the LLC for the sake of time.
Oh, just, yeah, anyone.
Yeah. Okay. So an application was made by the fourth defendant, the LLC, by summons issued on November 16, 2020 for an order pursuant of Order 15, Rule 62, directing that he be removed from the proceedings, and an order pursuant of Order 18, Rule 19, 1A, B, and D, that the inherent jurisdiction of the court, that the action be struck out as against the LLC on the grounds that it is frivolous, vexatious, and an abuse to the process of the court. The action was in relation to Windermere Island. This was a privately owned property in the Bahamas. The plaintiff, George Damianos, was a licensed real estate broker at Damianos Sotheby's International Realty. The first defendant was BOB, the bank of which the property was mortgaged. The second defendant was Windermere Development, which was the developer. And the third defendant was the principal, Joseph Carey Rich. The fourth defendant, the LLC, of which who acquired the said property from the bank around 2018. Around 2003, I guess just a background of what happened. Around 2003, the bank advanced the loan to the developer. At this time, the loan was secured by a debenture and a first demand mortgage from Windermere Island Development Limited to BOB over the property. Later in 2005, the loan increased. I guess they went back to the bank for more money because it increased. And it was further secured by a supplemental debenture and a further charge again from the developer to the bank. The loan went into default and the bank had agreed to refrain from collecting money due under the consideration of the promissory note dated the 27th of June, 2011, and also a guarantee by the third defendant, Mr. Rich, of the same date. So
Stop right-
later on,
stop right there. I have a question for
Mhm.
bankers. Now look at how they got a loan first, then they came back for additional funds.
yeah,
My question is, do they look at or do they take into consideration the potential income from the property and the risk that can occur and happenings in between granting of the loan and the completion of the project? Because a lot of these mortgage matters, especially do with developmental property, you will see they default.
yeah.
And that's the part I don't understand, is as if whoever is actually doing the review and the projection and looking at the bank obtaining his funds, something is wrong with the calculation.
Ms.
Anyhow,
Asha, I think it's
go
looking
ahead.
more at the what they will generate once completed and not taking so much into consideration
To get
uh,
to completion.
what could go wrong.
Exactly. When you read a lot of these, you see how much money they borrow. And these people are only borrowing, just like my ma used to say, on the bare backside.
Yeah.
There's nothing behind it.
Yeah.
They actually have no liquid cash.
No.
Anyhow, go ahead. I just wanted to keep it in mind.
Okay, so later on, the bank subsequently became entitled to exercise a power of sale under the mortgage and debenture. The bank entered into a listing service agreement with the plaintiff, Mr. Damianos, which stated that he would have authority to act as the bank's agent for listing, marketing, and sale of the defaulted property. It also stated that the bank was to pay the plaintiff 6% of the sale price plus VAT upon completion of the sale. The terms of agreement would be effective from the 6th of June 2016 to the 5th of June 2017. However, in May 2017, the plaintiff discovered that the bank had conveyed the property to the LLC and had sold, assigned, and transferred the debt due by the developer under the loan, the security documents, and the power rights contained therein. So, of course, he was, I would say, pissed because he felt like the bank went behind his back and made arrangement and tried to cut him out of what he's supposed to have. So that's why the plaintiff argued that the conveyance of the property to the LLC was considered a sale according to the listing agreement, and that the bank was supposed to pay him the 6% according to the term of agreement. This was the reason why he took the defendants to court. So in the writ of summons filed by the plaintiff, he claimed he claimed a declaration that the bank had sold the property to the LLC for the purposes of conveyancing and law of property act and the agreement. The commission of $432,000 payable to the plaintiff under the contractual agreement and the breach of same. He was claiming for the damages against Windermere Development and the LLC for torturous wrongdoing against him. He was also claiming against damages for the breach of contract, interest pursuant of Section 3 of the Civil Procedure Award of Interest Act on all the sums due and owing for costs and other relief that the court deemed just. So after that, on the 25th of October 2019, the LLC entered an appearance to the action and filed its defense on the 28th of November 2019. And the LLC claimed that they had no knowledge of the loan documents or listing agreement. May 2017, it was in discussion that the bank regarding the purchase of the debenture and mortgage. On the 22nd of September 2017, it entered into a loan sale agreement purchasing the bank's rights, title, and interest in the loan secured by the debenture and mortgage. The loan agreement stated that no brokerage commission would be payable with regards to the transaction. The LLC was not aware that the plaintiff had an agreement with the bank and did not conspire with the other defendants to cause any loss to the plaintiff. The LLC did not induce the bank to breach the agreement made with the plaintiff. So the LLC application was brought under Order 15, Rule 628, Order 18, Rule 19, 1A, B, and D, and under the inherent jurisdiction of the court. Order 15, Rule 62A states that at any stage of the proceeding in any case or matter of the court may, on such terms as it thinks just, and either of its own motion or on application, order any person who has been improperly or unnecessarily made a party of who has for any reason ceased to be a proper and necessary party to cease to be a party. So he felt like he wasn't supposed to be involved in this case at all because he, as far as he concerned, he knew nothing about any agreement when it came to the plaintiff. Order 19, Rule 1 states that the court may at any stage of proceedings order to strike out or amend any pleading or the endorsement of the writ of action or anything in any pleading or on the endorsement of the ground that A, it discloses no reason, cause, or action of defense as the court may be, or B, it is scandalous, frivolous, and vexatious, or D, it is otherwise an abuse of the court. And may order the action to be stayed or dismissed or judgment to be entered accordingly as the case may be. In addition to the court enjoys inherent jurisdiction to prevent its process from being obstructed or abused and to stay or dismiss any proceedings which is regarded as frivolous, vexatious, or an abuse of the process. So the LLC's first ground of complaint was that the statement of claim failed to disclose a reasonable cause. And the statement of claim was and the statement of cause, the claim was comprised of 44 paragraphs, inclusive of 2 paragraphs that alleged wrongdoing on the part of the LLC, which were the paragraphs 43 and 44. 43 stated that the defendant well knew that the plaintiff had been engaged by the bank to market and sell the said property in combination with a common intention conspired to cause the plaintiff loss by the first defendant's breach of listing agreement. 44 stated that in combination with the second to fourth defendant knowingly induced the bank's breach its agreement with the plaintiff by the sale of property with the intention of causing loss and damage to the plaintiff. So the counsel of the LLC, Ms. Souls Hunt, argued with the statements made in the claim that they were merely speculations and that there was no evidence that the LLC had any knowledge of any agreement made between the plaintiff and the bank. For these reasons, she said there was no reasonable cause of action disclosed. Ms. Hunt supported her position by referring to the Bullen and Leaks Precedents of Pleading 12 edition, which addresses the manner in which the claim of conspiracy should be pleaded, found in paragraph 340, 341. I guess for the sake of time, that's on page 7 of this case.
Paragraph 8,
Pardon?
paragraph 18.
Yeah.
So they, yeah.
Yeah. In addition, she also cited the decision in the case between OBG Limited and Allen, 2007, where the House of Lords authoritatively determined that in order to induce a breach, a person had to know that he was inducing a breach of contract and to intend to do so with knowledge of consequences. The court agreed with Ms. Hunt that claims against LLC were not sufficiently particularized. Even though the conspiracy was a serious allegation, the claim did not clearly set out the basis upon which the plaintiff alleges a conspiracy to cause him loss. However, the claims against the LLC in paragraph 43 and 44, assuming that there was some truth, clearly raised issues that were fit to be tried by a judge. In this case, there were no particulars to support this claim, but the court declined to strike the action. As usual remedy would be to make an application for further and better particulars. And that's in paragraph 18, 19, and 13 of the Supreme Court Practice 1999. The LLC's second and third ground of complaint were that the statement of claim was frivolous and vexatious and otherwise an abuse of the process of the court. While no evidence is permitted for purposes under the application of Order 18, Rule 19(1)(a), affidavit evidence is accepted under Order 18, Rule 19(1)(b) and D, or the inherent jurisdiction of the court. So on behalf of the LLC, Samuel Byron swore two affidavits in support of the summons. And Mr. Byron was actually the managing partner of both Cross Harbor Capital Partners and the LLC. In May 2017, Cross Harbor entered into discussion with the bank regarding the sale, rights, and title of the interest of the loan. Their initial offer was rejected, and they continued to negotiate. During the negotiations, Mr. Byron was not informed of any existence of terms of listing agreement. On the 22nd of September 2017, a loan sale agreement was finally entered between LLC and the bank. In the agreement, the bank advised that there were no brokerage commission in connection with the transaction, and agreed to indemnify the LLC against any such payment. The transaction closed around March 2018, subject to regulatory approval. The LLC was not a part of the listing agreement, and Mr. Byron noted that no agent of LLC was aware of the agreement before the transaction. The LLC did not conspire with the developer and Mr. Rich to cause any loss to the plaintiff. The loan was just thought of as a great investment opportunity. Mr. Byron also stated that he was not aware of the listing agreement until the commencement of the action. Mr. Byron further stated that he became aware of the loan through mutual acquaintance of him and Mr. Rich, and discussed with Mr. Rich the refinancing of the development of the property, which seemed to be a viable investment for the LLC at the time. After closing the transaction, Mr. Christensen, a consultant engaged to assist with property development assistance for local real estate agents for leasing and purchasing property in the vicinity of the said property. Mr. Morris, who was the broker for the plaintiff, they tried to contact him. So they claimed they tried to contact him, but he never responded to them. That's about what got me to, I don't know. It was a simple, he stated that it was a simple loan transaction. There was no release of satisfaction and no issuance of a new loan or security documents. It was structured to ensure that LLC retained priority and saved on costs. Mr. Byron believes that LLC should not be a part of the action in this circumstance. So after that, the plaintiff also swore an affidavit in opposition to the summons. He stated that he is doubtful that the LLC was not aware of the agreement with the bank. The listing agreement stated that anyone who was interested in the property was to be referred to him. He also stated that it was unlikely for the LLC not to be aware of his exclusive right to market the property, since Mr. Byron is the managing director of Cross Harbor, and Cross Harbor entered into negotiations with the bank in March of 2017. Further, in February 2018, an agent of the LLC, Mr. Christensen, was informed by a broker of the plaintiff, who was Mr. Morris, that he informed the broker, Mr. Morris, that the property was listed with the plaintiff for sale. In March of 2019, Mr. Christensen had asked Mr. Morris to remove the property from the plaintiff's website. The LLC likely became aware of the property through the plaintiff's marketing efforts or his relation to Cross Harbor. The plaintiff believes that the defendants, including the LLC, knowingly excluded him and cleverly constructed the transaction as if it was a transfer to assist the bank in avoiding its obligation under the listing agreement. So I'm ending now.
No, go ahead.
Um,
It's a good case.
So Ms. Hunt made several submissions. She stated that if the court determines that at the trial that the bank breached the contract and is liable to pay the commission to the plaintiff, there would be no further loss suffered by the plaintiff for which the LLC would be liable. She further submitted that there was no evidence to establish the LLC conspired to cause the plaintiff's loss. No document presented by the plaintiff supported claim that the LLC had any knowledge of intention. But I mean, okay, going toward the end, I see, like after all that, I guess they were, LLC, their counsel was arguing that plainly that they did not know evidence. The plaintiff did not know real evidence to come against the LLC. But I think, would it be another part to this case? Because,
Yep, there is.
yeah, because I mean, I
Mhm.
want to know what happened, because it seemed like they have to reconvene because the court kind of gave the plaintiff more time to gather proper evidence. Because I guess even though he didn't have his evidence together, I guess the court still kind of side-eyed the situation, because there was like, okay, maybe there's some truth to what's going on because he's still involved in some way.
But you see what the judge said at paragraph 33. She said it may well be that the plaintiff will face difficulties in
Difficulties, yeah.
the case. A claim of conspiracy is such that cogent and convincing evidence will be required to prove it. And he's
Mhm.
outside of the
Yeah.
whole communication chain. So unless he could get his hands on some documents to prove that they were aware, I mean, he's just shooting in the air.
Yeah.
That's my whole point. You're making this claim on what basis? You need to have some kind of paper, some kind of documentation to prove it. I mean, but common sense tells you if the bank sign an agreement for a certain period of time and then ends up selling it,
Yeah.
one, how did they become aware that the property was up for sale? Who told them? Two,
Yeah.
when they went to the bank knew that it entered into agreement. So why didn't the bank then call them and say, we found a buyer?
Right.
Because they know how that arrangement work with a realty company.
Yeah, they got to pay out money.
You have to pay out the money. Now, whether you found a buyer or not, if you didn't put that provision in there, and I think their agreements are standard. I think they get paid whether or not they find them or you find them. So
Yeah,
again,
because he did say In addition, it did say that if they did find somebody, they were to refer them to him.
Right, so that
Mm.
he gets his commission.
Yeah,
And so, so looking at it, I mean, whether he should go behind Windermere or go behind BOB, I think it starts with BOB.
yes,
It's a breach of contract. Because all BOB saw was that, guess what? Someone was interested in it, they'll be able to get this off their books, let's sell it.
yeah,
But they knew that they had an agreement in place. And even if they did it swiftly and didn't realize it, they knew they had to pay.
yeah, I think that's really going wrong. They really,
Yeah, but it's in all consciousness. He may not be able to prove that
no,
LLC knew. Yes, LLC needs to be a party to it because they purchased the property. And
Yeah.
now they're gonna, on their side, have to prove that they had no knowledge of it, which seems very weird
yes,
because you're buying it from a bank and you have a lawyer. You know what I mean? You would have
Yeah.
to go and get and get a title of opinion on this to purchase it. So it doesn't add up.
That's why I say, I think the court kind of helped him up in that situation because you could see they had some kind of knowledge of something, but it's just sad that he just out of the loop.
Mhm. They're just trying to get them out of the $400,000 and they got 7.2 million.
Whoa,
They're just trying to chip him.
So
this is-
overall, he lost?
I have to
No,
find the
no.
rest.
No, he hasn't lost yet. He has to go to trial.
He had to go to trial. Okay.
Yeah.
Okay.
And this,
Is
and this,
is there a part two? Is there
yeah, it's not out yet.
Oh wow. Okay.
It's not out yet. Because the judge wrote this in 2021 in March, so just over a year ago. Matters don't come up that quickly.
Hey,
this
that's
is-
hot.
Huh?
I say this hot.
Yeah, this is a good one. This is a good one. Yeah. So you see, even from the bank perspective now, the bank went ahead and they sold it. But now you have another player in this agreement, which is the real estate company. So all of that you have to think about. Now you say exciting these is mastering mortgages. All right, Cornell versus Maltby.
Okay. So Cornell versus Maltby.
Mm-hmm.
Okay, so I guess a summary, a house was mortgaged to a bank. And the house was then let to tenants at an I guess they were renting it for £1,000. Tenants were protected as against the mortgagor by the Rents Act. The tenancy was not binding on the bank. So what happened then was that the mortgagor's wife took a transfer of the mortgage and sued for possession. And the purpose of obtaining the possession was not to enable the wife to sell in her capacity as transferee of the mortgage, but to enable her husband, the mortgagor, to do so. All right, so we go to background on the case. So Mr. Cornell lives in London and he owned this house that I guess had 9 bedrooms. And he had an agent, somebody was there, I guess, collecting, who was looking after the place and collecting the rent. So given the size, they figured it was suitable for students to rent out. The agent allowed students from the University of Sussex to rent a house. And 2 of them became tenants. So they were Mr. Motley and Mr. Jack. So they were let into possession for a term of 1 year. And they had to pay rent at a certain amount per month. And it expired at the end of that particular year. While Mr. Motley and Mr. Jack, Maltby and Mr. Jack were tenants, Mr. Cornell borrowed money from Barclays Bank and mortgaged his house to secure the loan. The sum of the loan, the amount he borrowed was £2,500. And he executed that legal charge in August of 1974 in favor of Barclays Bank. To cover any monies which might from time to time be owing to the bank. But in that legal charge, there was a clause which in common form stated that during the continuance of security, no statutory or other power of granting or agreeing to grant or of accepting or agreeing to accept surrenders of leases or tenancies of the mortgaged property or any part thereof shall be capable of being exercised by the mortgagor without the previous consent in writing of the bank. So I take that to mean that with him doing getting the loan from the bank, this clause was there and this prevented him, or he should not have, I guess, rented it out. And he couldn't have gotten possession or without instructions or actually consent from the bank. Did I explain that right, Miss?
Mhm.
Archer?
ahead.
Okay, all right. So my understanding of it, so that meant he signed the charge for the loan in 1974. This legal charge subsisted to the bank. Mr. Cornell could not let the premises or accept surrenders without the consent and writing of the bank. So the tenancy of Mr. Motley and Mr. Jack came to an end in December of 1974, and the house was then re-let to 2 other students. Mr. Motley became, because he was not re-let, he wasn't, I guess, they didn't rent it or re-rent it to him because they thought he was leaving and moving to the United States, but he didn't go. And he stayed in the house. Several other students also did that. And all of this would have happened, I guess they said the important thing to notice that the bank did not give its consent to renting to some of the other students. But no one asked the bank for its consent because they didn't realize it was necessary. So with no interference, nothing happened. Okay, so then Mr. Cornell wanted to get possession of the house because he wanted to sell the house. He felt that he could have gotten a high price or get it sold at a good, reasonable price, I guess. But in order to do that, he needed to get vacant possession of it. So he started the proceedings. I guess he made a complaint or filed something to say he wanted possession based on nuisance. Is that nuisance? Nuisance and annoyance.
Mhm.
But then he dropped it. So he went to his attorneys for advice. And after consulting them, he went to the bank and told them about the tenants that were in the house. Seeing as the bank had not heard about it and the various changes in tenancies, when they were told, they made it clear to him that they had no intention of taking any proceedings to enter the property or put the tenants out or do anything of that kind. So the bank were not concerned to get possession of it. So Mr. Cornell, I guess, went back to his attorneys, I guess, trying to think of a way in which he could get possession of the house, or a good way or the right way. So what would have happened then is that Mrs. Cornell, his wife, decided to pay the bank off so that the bank will then not have, I would say, an interest in it. So it was then where she did, I guess he wouldn't have no longer needed the bank's consent in order to get vacant possession to try and sell it. So she paid the $2,500 that was owing to the bank and took a transfer of the charge. The bank transferred it to her and then she went and brought proceedings against the tenants seeking possession. So she would have told the tenants that she stood, I guess it's no longer the bank, so she stood in the shoes of the bank, and seeing as how, and seeing that the tenancy was granted without the bank's consent, it was void. So she was seeking to recover possession. The judge accepted her submission, and he held that the wife was entitled to possession of the premises and and she could have put Mr. Markley and the other students out of the house. Now, on the other hand, what they were saying is that when the bank holds a charge and there is a clause in it whereby there are to be no tenancies granted or surrendered except with the consent of the bank in writing. In those circumstances, if the mortgagor does not thereafter grant tenancies without the consent of the bank, and if the mortgagor does grant tenancies without the consent of the bank, those tenancies are not binding on the bank, and the tenants are not entitled to the protection of the Rents Act. Then no, I guess this is where they live in the UK, Miss Archer. We have a
Yep.
we have a protection of Rents Act in the Bahamas.
Yes, we do.
Oh. Okay, so that particular part was decided in Dudley v. District Benefit. So that's Building Society v. Emerson, 1949. So Ms. Cornell relied on that particular case in order to bring this action to the courts. Should I go on?
You reached the Court of Appeals, yeah?
Well, she did. So his decision, I didn't reach it yet. The judge accepted that submission, and his decision, he said it opens the way to widespread evasion of the Rents Act. If the owner of the house wishes to obtain vacant possession, all he has to do is charge it to the bank for a small sum, then grant a new tenancy without telling the bank. Then get his wife to pay and take a transfer. And the wife can sue the tenants for possession. So that's what happened there when Mr. Cornell went and trying to get possession of the house. He got Ms. Cornell to do it. So we have here where the courts left the legal effect of the transaction unaltered, but declared it to be unreasonable and against conscience that the mortgagee should retain as owner for his own benefit what was intended as a mere security. So it's clear in this transaction, Mr. and Mrs. Cornell had an ulterior motive. It was not done to enforce the security or the payment of the principal or interest. It was done for the purpose of getting possession of the house. in order to resell it for profit. It was done to avoid the protection which the Rent Acts afford to tenants in their occupation. If Mr. Cornell himself had sought to evict the tenants, he would not have been allowed to do so. He could not say the tenants were void, the tenancies, he could not say that the tenancies were void. He would have been stopped, how you pronounce it?
It stopped.
It stopped from saying so. They would not, they certainly would not, they certainly would be protected against him. But they were not, the question arose, were they protected against the wife? Because she's now the transferee of the charge.
And they said,
She's
did they
doing it for simple, and they said what? On that simple ground, it seems to me that this action fails and it should be dismissed.
but she wasn't
So-
exercising her power as a mortgagee.
She was not exercising her power as a mortgagee. What he said was, Lord Denning was, a mortgagee will be restrained from getting possession except when it is sought bona fide and reasonably for the purpose of enforcing the security, and then only subject to such conditions as the court thinks fit to impose. When the bank lends money, it may be right to allow the mortgagee to obtain possession when the borrower is in default. But so long as the interest is paid and there is nothing outstanding, equity has ample power to restrain unjust use of the right to possession. The wife was not exercising her power as a mortgagee in order to protect or enforce the security, but in order to obtain possession on behalf of her husband. Since the husband as landlord could not obtain an order for possession against the defendants, as they had a statutory tenancy protected by the Rents Act, the wife is not entitled to an order of possession. So the order of possession was denied.
Yes. Though, even though after that case was heard, a lot of other judges disagreed with that decision.
Yes, ma'am.
So she's trying to circumvent.
She was trying to circumvent the court. I like her though. She trying to use her marbles. In this case, she did the opposite of Mr. Mitchell. Mr. Mitchell wife who ain't show up on his behalf at all. She fight for her husband.
She's fighting for her husband, yes.
She was fighting for her husband.
Fought for her husband.
Yeah.
She did. She really did. She did try. Must give it to her. She tried.
Yeah, she tried.
Lost, but tried.
Look, well, she tried. Mrs. Mitchell was missing altogether.
Yeah, she wasn't on. She wasn't dealing with that at all. She meant she was not coming to court. I don't blame her.
Yeah, this one was interesting though, because then that means that, I don't know, I mean, you could tell me if we have something in our, like how, when he signed the charge with the bank, there was a clause in there that stated he could not have, rented it or obtained possession of it or anything like that without consent of the bank. We have something like that in our documents?
And some they do. It depends.
Oh,
Yeah, it depends on the mortgage deed.
Yes,
There
they
are
do.
okay.
some that says you cannot rent without the prior permission.
Without prior permission of the bank.
Yes. Mhm.
Okay,
Yeah.
all right.
You have to read the fine print. There's certain things you cannot do, and then there are certain obligations on you as the mortgagor. things that
As a
you have-
mortgagor.
Um,
Okay,
They can also put a clause in there that if you do rent it out, your interest rate would go up.
okay. All right,
Is it,
huh?
it changes it. It moves from being a personal home to a commercial one.
Yes, It does. But it was 9 bedrooms, so I guess that's why he decided he would go and rent it out to the university students.
Yeah, but a lot of people have 9 bedrooms, they don't rent it out.
No, no,
But
no,
that-
no, nah.
That's
In the
what he,
Bahamas?
not in the
That's
Bahamas.
commercial.
That's commercial,
Yeah. Yeah.
commercial. He should have thought of that before he signed the documents.
I don't think he missed clause 4.
Yeah, he missed that clause. But
He
then,
missed
like,
that.
like she said, he had a brilliant wife.
She surely did. She paid that off, so that means it was no longer the bank's decision in order to grant him permission to go ahead and obtain possession so that she could put him out and sell it. She could put out the
Mhm.
tenants and sell it.
Yeah. She just found a way to go around the law.
She was circumventing.
Yeah, she was circumventing. See, if she was just doing it just for, let's say it had nothing to do with the tenants. But let's say she's just saying like, I'm tired of him being late on this payment, or we just
Okay.
get rid of this debt. That's different. But when you're trying to put people out, no, they're not gonna allow you to just take tenants and put them out on the street.
So what if she tried to sell, like even here now, what if somebody just not put them out, but they just try and sell the place with the tenants in it?
No, you
Why?
could do that.
Okay, all right, all
Yeah.
right. She just couldn't put them out. That was the
No.
whole
Why-
crux
yeah,
of the matter.
She wanted vacant possession.
Yeah, she wanted vacant possession. Okay.
That's what she wanted.
Yeah, she should have been smart and leave the
Exactly.
people in. Yeah, and just try and sell it just like that.
Exactly.
Let it become the new owner headache, which if they want them in or not.
Because
Okay,
if you sell it like a commercial building, you will get more money. So she should have just sold it with the tenants.
sold it with the tenants, yeah. Yeah.
And let them decide that. Give the people 3 months notice or 6 months notice, whatever's
ownership.
reasonable for them to find out accommodation, and then say that we will no longer be letting these apartments.
True.
Remember, the court always look when you make a decision of whether or not you have an ulterior motive and whether the notice that you gave is reasonable. It's just like if you're renting apartments, you can't go to the person, they say, oh, you didn't pay the rent, I'm throwing you out.
Okay, so if she had given them a 3-month period to vacate, then she would have been fine?
It depends. If their students and the semester isn't over, I doubt it.
Okay.
Yeah.
Okay, okay.
So that a reasonable covers all areas, all aspects. So all those things you have to take into consideration. All of those. All right. So we are on module 5. That's where we are.
Yes, ma'am.
Mortgagors, duties, liabilities, and rights. So we now going to the wife. All y'all who trying to take care of your husband's business. So repayment. Now we know that's one of the primary obligations. We can't be like Teresita, who said she was not behind. So one of the primary obligations of the mortgagor is repay on demand the principal, the interest, and any sums owing to the mortgagee. The mortgagor also agrees to repay amounts of principal and interest from his account at certain intervals, and normally it's once a month. I don't know sometimes why some people, if they go to the bank, let's say they go to sign the document and they say they're signing it on the 7th, but they know they don't get paid until the 25th. Why don't they adjust the date at the time of signing? Or why doesn't the loan officer indicate, looking at, knowing the payday, why do they have it where they sign sign it and then it's due on that day, that means that they're always late.
But they could adjust it, Miss Archer.
Yeah, but they
Something
put for
adjusted.
a couple years. when they go and they check and they see late fee, they say, why do I have late fee? Not
Yeah.
realizing the dates don't coincide. And I've seen that happen in the banks.
Yeah, I've seen it happen. But
Yeah, they could have what?
they could adjust the date, even though they signed on a particular date. And
Yeah.
then,
What I'm saying is that even though the client isn't cognizant of it, because all they know is, okay, I get my mortgage finally, I'm saying the loan officer should be the one to indicate that's a flag right there. Or they get paid on this day, they're signing on this day, but they don't coincide.
yeah, yeah.
That's all I'm saying. This is another service that you could provide.
Yeah,
So if the mortgagor fails to repay the principal and interest of the mortgagee has the right to pursue a number of legal remedies, which we have seen in light of the mortgagor's breach of contract of the terms of the mortgage agreement. The mortgagee in most instances will likely seek to exercise its statutory and contractual power of sale and sell the mortgage property in order to recoup the outstanding amounts of principal, interest, bank service charges, and any other funds that are owed to them under the terms of the mortgage. The mortgagor is afforded some protection in law in exercise of the power of sale by the mortgagee, since the mortgagee has a limited or equitable duty to the mortgagor and any guarantor of the mortgage's debt to take reasonable care to obtain the true market value of the property at the date on which it decides to sell. And the case for that is the same one we quoted from that case, Cockmere Brett versus Mutual Finance. And then we'll also take a further look at the issue of market value when we look at the Homeowners Protection Act. And we'll look at the Homeowners Protection Act at the beginning of next class. And I've just sent it to you all so you can read it. So notwithstanding this equitable duty, the mortgagee does not have a duty to take any action to preserve the value of the security in the exercise of its security rights ahead of obtaining possession and control of the property subject to the mortgage. And we just saw that in one of the cases. In the exercise of his power of sale, the mortgagee is permitted to exercise such power even though the mortgagor may have already agreed to a sale, which would provide sufficient proceeds to pay the whole amount of the mortgage debt. However, the mortgagee may be prevented from selling the mortgage property under power of sale if the mortgagor has tendered the whole sum before the sale. So even in exercising his statutory and contractual power of sale, a mortgagee is not permitted to sell the mortgage property to itself, as this action would amount to a foreclosure. According to the Homeowners Protection Act, the mortgagee shall not sell the mortgage property to any of the following parties: a director or employee of the financial institution, an immediate family member of a director or employee of the financial institution, a company beneficially owned by a director or employee of the financial institution, any person who by the nature of their intimate relationship with a director or employee of the financial institution would be given more favorable consideration as a result thereof. So you know that normally used to be the story made by the borrower saying that their property, that someone in the bank sold their property to their cousin, their auntie, or to someone else in the bank. And so the Homeowners Protection Act is set out to give protection to the borrower. So once the mortgagee has sold the mortgage property under power of sale, it is a trustee of the proceeds of sale. And to avoid a breach of trust action being brought against them, they have to pay the proceeds as follows: any prior encumbrances, the cost of the sale, Then the monies that are payable under the mortgage agreement, any subsequent mortgages that they have, any other debts where the mortgage property is a security, and then the mortgagor, if anything is left. Any surplus proceeds from the sale of the mortgage property after payment of the foregoing, and particularly the outstanding principal and interest, must be paid to the mortgagor. Any shortfall in the sale of mortgage property permits the mortgagee to sue the mortgagor independently for the remaining debt in a separate action. Because that's the only way the bank could recover what's outstanding. So under the terms of the mortgage, the mortgagor covenants to the mortgagee that she is the beneficial owner of the mortgage property, which is an implied promise by the mortgagor that she has the power to convey the property. The mortgagor also covenants as per beneficial owner that the mortgagee is entitled to possession, and that the mortgagor will execute further documents to perfect the mortgagee's title if required, and that she has not done anything, nor will she do anything that will prevent the mortgage from operating according to its terms. With regard to leaseholds, the mortgagor also covenants as beneficial owner and or landlord that the lease is valid and that all the obligations under the lease have been or will be performed. Insurance. The mortgagor is required to insure the property and keep it in good repair and condition. And I know this is always a contention between the mortgagor and the mortgagee. If the mortgagor defaults in this obligation, the bank, mortgagee, is permitted to do so. However, the cost to insure the mortgage property will constitute a secure debt and effectually gives the bank the power to apply insurance monies to repairing the property and or discharging the debt. The mortgage also allows the bank to make payments of the insurance premiums upon which the mortgagor is liable without affecting his or her liability under security. So under Section 21B of the Conveyancing of Law Property Act, 1909, a mortgagee, where a mortgage is made by deed, has the power, inter alia, to insure and keep insured against loss or damage by fire, any building or any effects of property of an insurable nature, whether affixed to the freehold or not, being or forming part of the mortgage property, and the premiums paid for such insurance shall be a charge on the mortgage property, in addition to the mortgage money, and with the same priority and with interest at the same rate as the mortgage money. So now you see why the bank takes it upon themselves to insure the property. Because by law, they can do so, and the security attaches to that debt. And if the bank exercises its power of sale, the bank can then take those funds from the receipt from the sale of the home. By virtue of its power to insure, the mortgagee is afforded statutory and contractual protection by way of the terms and conditions of his indenture of mortgage. If the mortgagor fails to pay the insurance premiums regularly, as she is required to do so under the terms and condition of the mortgage document, the mortgagee is given the power to pay the premiums at the mortgage's expense. In order to protect itself, the mortgagee will often notify or require that the mortgagor notify the insurance company of his interest in the property. And should the property be subsequently destroyed by fire, the insurance company will either pay the mortgagor the amount insured on consultation and or approval from the mortgagee, or pay the amount insured directly to the mortgagee as loss payee, subject to the terms and conditions of the insurance agreement. So under section 25 of the act, a mortgagee may require or specify that all monies received on an insurance be applied in or towards the discharge of the monies due under the mortgage, without prejudice to any obligation to the contrary imposed by law or by special contract. A mortgagee and loss payee for the insurance monies may apply the monies received to the outstanding debt owed to the existing mortgage in lieu of repairing the damaged property, subject to any specific terms or conditions of the insurance agreement to the contrary. A mortgagee may wish to request that customers sign an agreement to incorporate specific terms in his existing mortgage document to allow it to apply insurance monies to the outstanding mortgage debt, inclusive of an indemnification or release from liability for such application. And that's so that it is protected contractually as well as statutorily by law. The mortgagor is also required, under specific terms of the mortgage, to pay all rates, assessments, stamp duty, charges, and real property taxes applicable to and affecting the mortgage property. And this responsibility applies to the payment of all utilities, the taxes, and other charges that may be leveled against the property in terms of the maintenance and its upkeep. If the property falls into disrepair and has to be sold under the mortgagee's power of sale for default of payment of the mortgage debt by the mortgagor, and the proceeds of the sale are insufficient to satisfy the outstanding principal and interest, the mortgage property may be sold at an undervalue to its true market value. And the mortgagee may pursue an action for debt, again against the mortgagor for the shortfall. And that includes the cost of the sale and any bank charges or expenses. The mortgagor has a contractual obligation to inform the bank of any encumbrances, any encroachments, nuisances, disputes, zoning, town planning, and any other matter that affects the mortgage property. In the event of a sale of the property by the mortgagor, the bank must be informed by the mortgagor of the prospective sale of the property, and his prior and written consent must be obtained ideally before the commencement, but certainly before completion of the sale. So under the Homeowners Protection Act 2007, the rights of the mortgagor is to provide, under the primary purpose of the act was set up to provide protection and relief to homeowners who, having defaulted on their mortgage loans or breach any other obligation under the mortgage agreement, find themselves subjected to the mortgagee's eminent exercise of his right of power of sale. So there are three major features of the Homeowners Protection Act. One, obligation of the mortgagee to give notice prior to instituting court proceedings or exercising any non-judicial power of sale. Two, the right of the mortgagor to apply to the court for relief. And three, power of the court to grant relief to the mortgagor. The fourth major feature relates to the long-standing enduring nature of judgments related to mortgage loans. Section 23(3) of the Act states that no mortgagee shall recover from any mortgagor any sum owing under any judgment by the court for the repayment of any sums borrowed by the mortgagor from the mortgagor after the expiry of 6 years from the date on which judgment was obtained or the date of the last payment pursuing to that judgment. Are you aware of that?
You could explain that, please, Ms. Archer?
Can I explain that?
Yes, please.
Okay, so what it's saying is this, is that when they get a judgment, when the bank receives a judgment,
Yes.
or when the judgment was obtained or the date of the last payment,
Uh-huh.
After 6 years, the bank cannot go behind you for that money.
At all? Judgment
No.
can't be extended?
No,
So if they had vacant possession and they sold a portion of the property, you never paid anything else. They got insurances for any damages that would have happened in between there. You still owe them money, because of all their fees and insurances. After 6 years, you would not be liable.
that's what it says here.
That's what it says in black and white. I know I've heard that before, but I wanted you to explain this to me, for my non-learned friends.
Mhm. That's what it says. 6 years.
Okay. So would the person then be able to get possession back?
No, why they getting
That's
possession?
a no, right?
No, no.
Because it would have already been sold. But what it
Yeah.
means then is that they can go and obtain other real estate without this judgment over them. Is that correct?
Right. So they will no longer be saddled with an outstanding judgment hanging over their head.
All they have to do is wait out 6 years.
Where there is a shortfall in the sale proceeds of the mortgage property, and where there are no other assets or means of satisfying the residual debt. So if they don't have any property they can sell, they don't have anything else, then they are free to go.
But,
They
But
said
if they have other properties?
then they have to satisfy the debt because the bank is going to sue for the shortfall.
right. So only if they don't have any other real estate, but they have means of paying, they have a job. So what if they just choose not to
they'll have to
pay?
pay. Yeah, the bank will take them to court for judgment.
Hmm.
But after 6 years,
They still can't get no money.
Yes, after 6 years. You can't go after the person after 6 years. You can't come 8 years afterwards say, I need to get my money. You now have a job.
What if they haven't repaid it in 6 years? Does
Then the
it
debt
go-
is gone.
so it just wipes out?
Mhm.
But what does it do to their credit history though? To obtain any other
that-
loans from,
But that's a different story. We got to see how the credit, we're gonna look at the credit, we're gonna look at the Credit Reporting Act, but I don't think it's actually running at 100% as yet.
okay.
But we're gonna look at the Credit Reporting Act.
Okay.
So it says that it's a hard pill for the lending institutions to swallow, who either suffer losses when shortfall in such sales occur, or where they cannot dispose of properties due to depressed economic conditions. The act also lays out penalties and fines for breaches to that section. So where mortgagor is in breach of the mortgage agreement, under Section 4 of the Act, it outlines the specifics that must be included in writing to the mortgagor prior to the mortgagee instituting legal proceedings. The notice must be served either personally or by registered post upon the mortgagor at least 30 days prior to instituting such proceedings. The court may vary the method of service as it sees fit upon an ex parte application by the mortgagee. Upon receiving the notice, the mortgagor or a member of his family who has been contributing payment prior to the breach may apply to the court for relief. The court may consider requests for relief if it is likely that within 6 months, the mortgagor is able to either pay principal and accrued interest at a specific time, remedy a default consisting of a breach of any other obligation arising, or pay arrears. So you see, the act actually gives them 6 months to try to bring their mortgage up to date. In any of the foregoing instances, the court may, for a period up to 6 months, adjourn the proceedings, or on giving judgment, making an order for delivery of possession of the mortgage property, or at any time before the execution of such judgment or order, either suspend the execution of the judgment or order or postpone the date of delivery of possession. So where mortgagor is in breach of the mortgage agreement, Section 7, subsection 2 of the Act outlines the specifics that must be included in writing to the mortgagor prior to the mortgagee exercising his power of sale. The notice must be served either personally or by registered post upon the mortgagor at least 30 days prior to instituting such proceedings. Upon receiving the notice, the mortgagor or a member of his family who has been contributing to the payment prior to the breach may within 28 days of service of the notice apply to the court for relief to postpone the sale. The power of the court to grant relief in this instance is laid out in Section 9. The court may make an order to postpone the sale of the mortgage property for a reasonable period where it appears that the mortgagor is likely to pay any sums due under the mortgage, remedy a default consisting of a breach of any obligation under the mortgage, or pay arrears. So sections 4, 5, 6, 7, 8, and 9 do not apply to any legal proceedings existing at the coming into operation of this act.
Ms. Archer,
Yes,
I know you're explaining it, but I just have a question.
go ahead.
Okay, times have changed and all of that, right?
What
So
you mean?
then-
time of change?
Okay,
What do you mean?
use this with them saying that they have to serve by registered mail, right?
Oh,
Okay.
you mean like that? Oh, okay.
Right. So registered mail. Sometimes you don't get a receipt, right? But you know you registered it, right? Okay.
Mhm.
I'm understanding that you have to provide evidence, so you have to have a receipt in order for that to hold up in court, right?
Yes.
Okay. What, like, we communicate a lot through social media. You can send a email. It doesn't matter if you're in communication with this client. For instance, I could send you an email, sending you a demand. You acknowledge that you have a conversation with me. I send you another email saying vacant possession. You acknowledge it, all this back and forth. Why that can't stand up in court? Because you acknowledge all of this. Isn't that like in person to some degree?
They may not be on the other line. That could be someone else. That could be
Anybody
anybody
else.
on that email.
No, but okay, if you do it, if you track, I mean to say, you have been
Okay,
in
all right.
contact me from beginning.
All right, so let's go to the mortgage deed. Or that whole package that you give a client. In there, it must speak to notice. What constitutes notice in that arrangement of the mortgage? Does it state email? Does it state social media?
Okay, when you say the document, you're talking about the deed, you're talking about.
Yes.
Okay, okay, when what you're saying, no, right? But they're getting notice.
But that's
And
not
you have
notice, that's
evidence that they got it.
law, though.
Sorry?
That's not notice in law. Now, don't forget, so you're dealing with a mortgage. It's just like if you and I had entered into an agreement. If you and I enter an agreement to do whatever, build a house, buy a car, whatever, there's a section in that contract that speaks to notice. Now, if you state in your contract that notice is via email, then that is your notice. But it actually speaks to, generally in law, that for property, it has to be done personally or by registered posts.
All right, thank you.
Now, whether or not, like you say, times have changed, whether they're gonna use social media and all of that, everything, remember, is based on common law. So unless we change the law, then the lawyers would then lean towards other common law cases where the judges would have deliberated and spoke about registered posts and it being archaic, and this is the time. And then the local lawyer here would then have to get up and argue, saying that persuasively, this is the trend in which we are going legally. You see what I mean? You can't just change it.
Okay, but when you also, the other thing is in person, right?
Mhm.
How do you prove, for instance, I could take this, a letter, I know some persons hire, I think it's provost marshal, they have someone do it, right? But not, that is not always done. So for instance, me as a loan officer, what if I was to go down to, I can't serve them? So if I take a letter, they're not gonna sign to say they got it. What evidence do I have that it was delivered?
You don't?
So that means that that's null and void to some degree.
Yes.
So you have to have someone who, of an official person, deliver that.
Mm-hmm.
Okay.
Because remember now, in law, notice has a different meaning.
So then that means, Ms. Archer, that registered mail as well really won't be, I mean, even though they say registered mail or personally, when you do registered mail, what we get back is that the mail was registered. It's not so much that the person actually received it.
Yes, but your obligation is that it was registered.
Oh, okay, so you just need you just need evidence that you
That
would have
you-
actually registered it.
Yes.
Okay,
So that means that notice was dispatched.
okay, all right.
And then what you do is then in court, then you then state what that notice was. Now, there is a case that I hope I can find it in time for next class for one of you to present. There's a case where notice was sent, but the mortgagor never received it.
Ah, that's what I'm talking about right there.
I have
They-
a case for that. I gotta look for it for you.
They will argue that point.
Yes, and he did argue that point.
Okay, then,
Okay, so I'm gonna look for that case for you.
all right. Not for me to present, but you look for it.
Yeah, someone else, I'll assign it to somebody. Not necessarily to you, no. You know, I just go down the list and just pick a name.
Yes, ma'am.
So. To me, some students say that this whole HPA is like another stalling tactic. Like it just prolongs it. Because it still comes to the same conclusion at the end of the day that they can't pay.
Right.
But I guess the government wanted to do something to say that they're assisting. But the banks had already had a program in place where they would sit down with the customer and try to reduce the payments, extend the payments, give them more time. I mean, that was already in place, but there was no like a legal framework in place for it. So that's what the Homeowners Protection Act is supposed to be, a legal framework. So the mortgager's liability for any residual sums owing at the date of the sale of the mortgage property may be eliminated, and the mortgagee's right to pursue an action for debt may be jeopardized given the provisions of Section 11, subsection 8, which states that save for any surplus amounts referred to in subsection 7, the exercise by the power of sale shall discharge the mortgagor from any and all liabilities for any sums due under the mortgage if, at the date of the sale, a sum equal to or at least 1/2 of the principal and accrued interest has been paid to the mortgagee, or the mortgagor has been in occupation of the dwelling house for a period not less than 50% of the original mortgage term. The mortgagor may make an offer to purchase the mortgage property at market rate prior to the mortgagee accepting an offer to purchase the said mortgage property. The mortgagor has the right to request in writing a mortgage statement free of charge up to twice a year, and the mortgagee must respond to any such request within 30 days of receipt of the request. If the mortgagee fails to respond without having a reasonable excuse, any rights that it may have for the enforcement of the debt will be suspended until it has complied with the request. This relates only to those proceedings initiated after the coming into effect of this act. The mortgagor, at his own expense, may retain and instruct an attorney chosen by him from a list of attorneys approved by the mortgagee. He could also select an appraiser of his own choice from a list provided by the mortgagee containing at least 12 names of appraisers or assessors who have been approved by the relevant minister. The mortgagor may select an insurance broker registered under the Insurance Act of his own choosing. Where a mortgagor exercises his entitlement under Section 17 of the Conveyancing and Law of Property Act, the mortgagee must assign or convey the debt to the new lender without requiring the mortgagor or the new lender to pay any costs associated therewith. If a mortgagee transfers, assigns, or sells the mortgage's debt, the mortgagee must advise the mortgagor in writing not less than 30 days before the effective date of the transfer, assignment, or sale. So you remember when there was the bank, the commercial bank that sold the debt to another company. You remember that? And there was a lot of kick up in the papers and social media when the mortgagee sold the mortgage's debt, and they said that they were not informed. And that's what this section is about. This provision is in there to protect them so that they're aware of it before the transfer, because it was a bulk sale. You remember that, right? No, nobody remembers the bulk sale.
I kind of know what you're talking
Yes,
about.
I heard about it.
remember
You heard about it,
Yes.
yes.
Yeah. Mhm.
And this,
Royal
the
Bank.
notice, go ahead.
But from Royal Bank some years
That-
ago.
Yeah. And the notice must be served either personally or by registered post. The notice of transfer must include the effective date of the mortgage debt transfer, the assignment or sale, the name, address, or contact number for both the current mortgagee and the transferee, assignee, or purchaser, and a statement that the transfer of the mortgage debt does not adversely affect any terms or conditions of the mortgage agreement. The transferee, assignee, or purchaser must not vary the rate of interest applied to the mortgage debt with the effect that it is higher than the interest rate prior to the transfer, require the mortgagor to pay fees, administrative or otherwise, or charges with or arising from the purchase of the mortgage debt, or offer the mortgagor new payment terms that place the mortgagor in a worse position that he would have been had his mortgage debt not been sold. So you see, all this act did was just put into law the framework for what the commercial banks were already doing. We know they did the bulk sale, and in some instances, they didn't advise the mortgagor. We know that in some instances, the assignees attempted to change or charge fees, and that was not, I guess, in good business sense, that is not a good way to do. Because if you transferred a bulk of mortgages, you cannot just arbitrarily go and change the fees without the mortgagor being aware of the whole arrangement. And then if you're gonna charge fees and they already were behind in their payments, then how are they going to pay? Then you're forcing them to go into a power of sale, for the bank to take action for power of sale. So everybody would have received a copy of the Homeowners Protection Act. I sent it
Okay. Ms. Archer,
Yes.
other rights and entitlements. I know the time, right? But my last question for the night.
Go ahead, man.
Other rights and entitlement, discharge from any and all liabilities for sums due at date of sale. I was looking, I swallowed that when you read it, right?
Mhm.
And I was pondering it. So I'm looking at this and I'm saying, and I'm asking you, this means then if a mortgagee has been living in their house, let's just say they have a mortgage for 30 years and they've been there for 15, and they somehow default on their home. The home is sold. This means that they're not liable for any residual sum. It should be discharged, or it should be eliminated. Is that what this is saying?
Why you saying it like?
I have to ask that because they still owe the bank money. So I'm trying to figure out if I'm reading this right.
That's what it says. Let me go to the act itself. Um,
Hmm.
okay, no, I'm reading section 1. You want to leave that till next week?
Yes, ma'am, please.
And then we're gonna read, we'll go through section 11, because that's where it is. That's
Okay.
11, subsection 8.
Subsection 8. Yes, ma'am.
Okay,
Okay.
that's just one of quite a few conditions on the exercise of the power of sale.
Okay.
What I wanted to do next week is, now that you have it, you can print it. And I wanted us to go through the act itself. Because only thing in the notes is we just pulled out the mortgagor. With, the protection that this act was supposed to give them, but you need to read the whole act in order to understand the framework that the government has put in place. So we'll look at that next class. And then we'll do module 6. And do you mind if I send you all some cases? Yeah.
This is for next week.
Yeah.
Will it be on the test? Then yeah.
When we meet next week, I'll tell you no. I think from 5 and 6, I'm gonna leave those for the final exam because they're more geared towards scenario questions.
Okay.
So I will confirm it. But so far I have done 1, 2, and 3. And I probably will just stop at 4 for the midterm.
All right.
That's okay with everybody?
Yes.
Yeah, because these ones now, when you're talking about the mortgagee and the mortgagor and his rights and stuff, I think the cases are more apt for those. Where you could use those and explain your answers.
Okay. So if it's more cases that can help us with our midterm and answering those questions, I guess we could use it as a review. If it'll
Yeah.
help.
Yeah, it'll help. It'll help when it comes to the final exam. And normally for the final exam, when I write it, I would normally give you the list of the cases that you need to read or read over. So you're not lost.
Okay.
Yeah. But I mean, for homework and for class, I normally like to give a variety of cases because you may present case A, but someone else may read case B, and you may prefer that story instead. So you could always choose which one. All right, so let me go look for some cases that I could send you all for next class. What I could find on the Homeowners Protection Act. And then some other ones on the power of sale. All right,
Yes, ma'am.
okay, so the midterm is units 1, 2, 3, and 4. It's agreed, correct?
Agreed.
Multiple choice and true and false.
Yes, ma'am.
Multiple choice.
You know true and false?
No, it was multiple choice.
Okay, all right then.
The true and
Multiple
false, if the true and false is bonus, yeah.
Okay, well,
What was the date
Oh.
again? August 17th?
yeah. Round the
Okay.
corner.
Yeah.
It's around the corner. Yeah. All right. So let me look for some cases so I can see if I can send those tomorrow. All right.
Okay, ma'am.
Okay. All right. So have a good evening. I know it's late.
Bye. You too.
Okay.
Good night,
Yes.
everyone.
Okay, good night.
Oh, hold
Good
on, hold
night.
on, hold on. Don't go yet. Don't go yet.
Okay.
Hold on, hold on, hold on. I was supposed to read you
You
what
said you
Miguel
send the
said.
app, which, is it the-
Yeah, I did. I sent it to everybody. Let me see what he say. Hold on. He wrote something.
something I don't
I
see.
think that was the YouTube, getting in for the link, right?
Yeah, you got
Getting
that
in
right.
for the YouTube videos. Yeah.
Uh-huh. Okay. All right then. All right then. We good.
Okay,
All
Okay.
all right.
Okay. So let me look for my cases for you all now.
All right.
And I like to keep you all busy, you know.
All right, Ms.
Yeah.
Hatcher. Okay.
Good night.
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 Hmm.